Well, back to tonight's top story, the catastrophic implosion of a submersible near the wreckage of the Titanic that killed 5 people. And now many legal questions are being raised, and we expect to see plenty of lawsuits relating to this tragedy. Let's bring in criminal defense attorney Joseph Tully. Joseph, great to have you on here. If you give consent, everybody's asking this, if you give consent to a dangerous activity like going down 13,000 feet in a sub, does that relieve the company of liability?
Not always. So there's assumption of the risk, which is an old common law term, which does relieve people, even if they're negligent, from liability because someone assumed the risk. You have to know the risk and you have to voluntarily assume it. However, if there's operational negligence, if the company was cutting corners, if they had an aversion to safety protocols, then that wasn't covered in the waiver, and therefore they'd be vulnerable to a lawsuit.
Interesting, because CBS reports the following, and I'm going to quote here: behind the marketing lingo, lawsuits and industry experts had raised serious safety concerns about the project years before the sub's disappearance. In 2018, a professional trade group warned that OceanGate's experimental approach to the design of the Titan could lead to potentially catastrophic outcomes, which brings up the next question, which is, if they warned the company, right? I don't care how many waivers you sign, if they warned this company that they were facing some kind of danger and they just blew the warning off, what is that? How does that change the equation?
It makes the assumption of the risk, it makes the waiver null and void. So you could say, listen, this was design defective, it was negligent in its design, and that was not in the waiver, therefore the waiver does not cover this.
Right, but then you go back to this, because a former passenger, his name is Mike Reese, and he said the following, quoting here: death is always lurking. It's always in the back of your mind. Before you even get on the boat, there's a long, long waiver that mentions death 3 times on one page, and that's what he keeps saying. And that's what others should keep saying. Listen, they made very clear that you sign these waivers, and they said, you kind of know, they explain it, they give you a kind of a tutorial. Here's what you're in for. You're going down. It's going to take this long. And it's one of those things where, why would you even have a waiver in the first place if there's a way for attorneys to get around them?
So the law is meant to be flexible. So a building, if it's rigid, will collapse during an earthquake. But if there's flexibility, it'll survive. So too, the law structure, our system, will survive if there's flexibility. And we need that human flexibility within everything. So there's 2 sides to this, obviously.
Yeah, it seems like it just kind of raises the liability for, we talked about adventure tourism with one of the guests, and he said, no, he thinks it's going to be robust still because a lot of people want to do some of these things. And I believe that. But the companies that want to provide these adventure tourism tours and stuff, their liability, it seems, has just gone up. Is that a fair assessment? I
think so. We've seen this. I think it boils down to, if you sign a waiver, if you're jumping out of an airplane with a parachute, right, on this guided parachute, you know what you're doing. But you don't sign that if you know that the person who's guiding you is an alcoholic and their hands are shaking. You wouldn't do that. So it's always going to be fact dependent.
Interesting. Joseph Tully, great to have you on. Appreciate it.